Great, thanks for having me. I just wanted to kick off by telling a little bit of a story. I've come to dread the question of what it is that I do for a living. First off, I tell people I work for the British Columbia Securities Commission, and the initial response from more people than I would expect is, so you employ security guards? Something along those lines. If I manage to get over that hurdle, I then move on to a bit of a discussion of what I do on a day-to-day basis as a regulator. And invariably, the facial expression I get is, I'm really sorry I asked the question. Anyway, I'm here to tell you that a lot of these people, you in the room, have changed that, because the amount of interest I get in my job these days because of fintech, cryptocurrency, and Bitcoin has exploded immensely. So much so that I even notice it in my own family situation. The other day, my wife told me a story. My youngest son was driving home. Sorry, he wasn't driving. That would be a bit challenging. My youngest son asked a question while my wife was driving him home, and his friend looked over at him and said, "What does your dad do for a living?" He responded, "My dad is in charge of Bitcoin." Well, that's not accurate for a lot of reasons, as you all know. I appreciated that he at least listened somewhat to what it is that I do. Anyway, the whole point of the story is, again, to reiterate, there's an explosion of interest in these matters, and we at the BCSC are doing what we can to be at the forefront of staying on top of these developments. A lot of people in the room know, but I thought I'd just start from the Commission perspective. We use the term fintech to describe a broad range of business models and emerging technologies that bring technological innovation to the financial sector. This includes new means of capital raising, new ways of interacting with clients, new methods of decision-making for investments, and new ways of trading. Emerging technologies such as cognitive computing, machine learning, AI, and distributed ledger technologies are being developed by both new fintech entrants and existing incumbents, and they carry the potential to dramatically change the structure of our capital markets. At the BCSC, our regulatory approach to fintech products and services is a supportive one where we work to facilitate new, more efficient paradigms while ensuring continued investor protection. We place an emphasis on collaboration where we can between industry participants and regulators. And this is done by way of examining whether the existing regulations are broad enough to cover the new fintech business models, and where they're not, working with the industry to understand the potential and the risks that these new business models have. Over the past 2 years, BCSC has engaged in numerous consultations with stakeholders in British Columbia to understand the nature and the growth of the fintech industry and how the current regulatory framework works to foster innovation or not, as some have explained to us. We recognize that the British Columbia's technology sector is the fastest growing in Canada, and that Vancouver's startup ecosystem has been ranked among the strongest in the world. The consultations that we've done have been important to continue our efforts to support the growth of our capital markets in this thriving sector. In February of this year, we published a notice and request for comment which set out the results of our consultations to that date, and we sought comment on potential regulatory action to clarify or modernize securities laws to benefit stakeholders. In total, there were 29 respondents from across a broad spectrum of categories: lawyers, consultants, academics, advocacy groups, and others in the industry. We received feedback on a number of topics, including crowdfunding and online lending, online advisor business models, cryptocurrency funds, initial coin offerings in cryptocurrencies, and just the future of fintech regulation generally. The responses we received were highly useful, and we are very thankful for those who took the time and energy to prepare a response. While the time I have today doesn't allow me to get into detail on all the responses, I did want to give some information about some of the highlights. At a high level, most of those responding, not surprisingly given the business that you're in, favored flexibility, innovation, and creativity in regulation. And we think the BCSC brings a lot of these hallmarks. We have done so in the past, and we would like to continue to do so in the future. There was also an emphasis not surprisingly, by some existing market participants on the need for a level playing field in regulatory approaches for both fintech and non-fintech businesses. That is certainly something that we need to keep in mind going forward. Some of the more particular issues that came up, many respondents were looking for more guidance from regulators on the determination of when crypto assets, particularly utility tokens, are securities. We've responded on that point in the CSA published CSA Staff Notice 46308 in June of 2018. It provides specific guidance on when tokens are likely to be an investment contract and therefore a security. In addition, respondents generally pointed to a shift toward tokenization of traditional securities and the creation of tokens with attributes found in traditional securities. And through all the conversations that we've been having, we've seen this as well. As part of the increasing sophistication among fintech businesses that are now recognizing the existence and the value of securities laws, very happy to see people recognizing the existence of securities laws because that has been a significant issue. We're seeing that our time is now being spent much less on determining whether or not a utility token is a security, and we're spending more time looking at the evolution of crypto assets and the infrastructure around crypto assets, so marketplaces, issues around clearing, etc. Respondents provided specific comments on the crowdfunding regime, including advocating for an increase in lifetime and annual raise limits, the expansion or removal of the eligible securities requirements, and a more harmonized crowdfunding regime nationally. These comments have been heard, and our staff have found them very useful in bringing them to the table when we're having conversations with our CSA colleagues. For those who don't know, CSA, the Canadian Securities Administrators. I wanted to switch to spend a little time talking about working with your regulator. The BCSC has a dedicated fintech team called the Tech Team that can provide you with guidance regarding regulatory issues relating to your business. The formation of the team in January 2017 formalized the BCSC's commitment to being a leader in fostering our fintech capital markets growth and developing a flexible regulatory framework that accommodates the impact of fintech in our capital markets. The BCSC Tech Team actively engages in outreach to the BC technology community, is interested in hearing from businesses, entrepreneurs, and other stakeholders whose activities relate to our capital markets. Fintech companies interested in discussing how securities regulation applies to their business can contact them at techteam@bcsc.bc.ca, or they can go to our webpage and see the Tech Team webpage. Our webpage also has some information about how securities laws apply to some of the more common fintech business models. Meetings with the Tech Team provide an opportunity for you to describe your innovative business model. Staff typically analyze the business model and they ask questions to flesh out their understanding and understand potential risks and regulatory considerations. We'll work with the firm to identify the regulatory requirements that apply and if exemptive relief may be needed for your business to operate as you would like it to. Staff may also discuss the firm's eligibility to participate in a sandbox-style test environment in which a firm may be permitted to operate under certain limits or conditions. Example of these limits or conditions are dollar limits on how much a client can invest or a limitation on a particular type of investor, for example, a sophisticated investor. The Tech Team also considers eligibility to the CSA's regulatory sandbox, which is a pan-Canadian approach to facilitating emerging business models in the fintech sector. Participation in the sandbox may allow firms to register or obtain exemptive relief from securities requirements under what we hope is a faster and more flexible process than through the standard application. And this will allow them to test their products, services, and applications throughout the Canadian market. For companies located in British Columbia, the BCSC will be your principal regulator and your Canadian first point of contact. The BCSC evaluates your business model and submissions, and to the extent that your business qualifies, we would discuss with the other Canadian securities regulators your entry into the CSA sandbox. If your business were considered by the sandbox, then the BCSC would stick handle the communications and reciprocal registrations or exemptions to the extent that that's necessary. Firms interested in meeting with the Tech Team and perhaps participating in the sandbox should consider the following. Ensure that you have a well-developed business plan and understand your business model. The regulators can only provide guidance with respect to securities laws, but we cannot provide business advice or legal advice. Approach the BCSC early in your company's life cycle so as to avoid the contravention of securities laws. And I can't emphasize this enough. If you start operating before you've considered securities laws and gotten the appropriate advice and approvals to the extent that you need them, you can end up facing our enforcement team or perhaps other complications, for example, being required to unwind capital raising transactions that you've participated in. So there could be serious consequences. Be prepared to discuss potential investor benefits and steps to minimize investor risks. Be realistic about the timelines and understand the role that you play in helping us meet these timelines and sharing information with us in a fulsome and as elaborate a manner as you possibly can. In our experience, the fintech companies that have had the most success working with the BCSC and the CSA have had the following characteristics. They took the time to understand the securities law framework themselves, or they retained people who had a deep understanding of it. This may be legal counsel, it may be other external advisors, or you may have employed that kind of in-house expertise. They were able to identify and understand where their proposed model would create risks to capital markets or risks to investors, and they were proactive in coming up with practical solutions of the risks. You'd be surprised about how many people want us to solve their problems, and that's just not how it works. It's not typically the role of the regulator to provide suggestions on how to design a business so as to reduce the risks that create the regulatory concerns. But what we can do is we can provide you with feedback and guidance on where we think the solutions adequately address the risks. As I said earlier, they engaged with the BCSC early, and they were transparent about future plans and potential future changes to their model. They were able to communicate the core facts of their business model, and these core facts did not change on a daily basis. We understand that a developing business model is fluid and that a business model will evolve over time, but it's important for business to understand that where these evolutions impact regulation, it requires regulators to reconsider that model in that light, and we may have to undergo a fresh analysis, and that will take additional time. To the extent that a business model's evolution is transparent and consistent, that reduces the need for repeated iterations of consideration, and it does considerably speed up the process. I strongly encourage you to approach competent legal counsel who understands the fintech area that you operate in to help provide you with some guidance on the regulatory environment. And the regulatory environment does not just mean securities laws. I think as many of you know and have experienced as you're developing your businesses, it may include compliance with anti-money laundering and terrorist financing, registration as a money services business, compliance with banking laws, privacy laws, or the consideration of other applicable foreign laws. Speaking of foreign, I've given a bit of a narrative of what we've been doing domestically, but we have also been active on the international front. We've been active in working with regulators around the world to understand developments and, where possible, to create a consistent framework for fintech regulation. To this end, the BCSC has a memoranda of understanding in place with several regulators in other countries: the Australian Securities and Investments Commission, the AMF in France, the Abu Dhabi regulator, and we are actively working on a number of other MOU right now. We're active participants and speakers in fintech conferences, both domestically and globally. Most recently, our staff was in Singapore about 2 weeks ago for the massive Singapore Fintech Festival, and we engaged in discussions with regulators from over a dozen other countries talking about fintech, regulation tech, supervision technology. It's very fruitful. I think that two other global initiatives that we're involved in are also worth mentioning, and that's our participation in IOSCO, the International Organization of Securities Commissions. In that capacity, the BCSC participates in the IOSCO ICO network, which is an informal network of global regulators that shares challenges and solutions in the use of crypto assets for capital raising. We're also part of the IOSCO Fintech Network, which was created in May 2018 and is intended to propose timely recommendations to IOSCO on cross-jurisdictional approaches across 4 work streams: distributed ledger technology, artificial intelligence and machine learning, RegTech and SoupTech, and finally a work stream focused on actionable lessons that we've learned from observing or collaborating in industry innovation. The BCSC is a contributor on all these work streams. The second initiative that I'll mention is the Global Financial Innovation Network, or GFIN, and we're a very recent addition to GFIN. GFIN grew out of a meeting that the United Kingdom's FCA hosted in March 2018 after Innovate Finance IFGS's conference in London, England. The FCA, BCSC, and 11 other jurisdictions, including Ontario's OSC and Quebec's AMF, have formed the network to not only share information across regulators, but to also facilitate cross-border sandbox-style testing in multiple countries. GFIN completed an open consultation process last month on its mandate, so stay tuned for further developments. I just wanted to close by referring to our vision statement, which is we want to play a leading role in securities regulation that inspires investor confidence and supports fair, efficient, and innovative capital markets. For us to achieve that, we need all of you to play a role in telling us what works and what doesn't. So to the extent that what you do intersects with financial innovation, technology, and securities laws, I encourage all of you to talk to our tech team. And you can tell them that the person in charge of Bitcoin sent you. Thanks.